All right, welcome back to the deep dive. Today we're going deep on something super important if you're renting a place in California, and that is your rights and responsibilities as a tenant.
Yes.
We've got some seriously useful resources you guys shared with us. The California Department of Consumer Affairs has this awesome guide called California Tenants, a guide to residential tenants and landlords' rights and responsibilities. And there's also the Know Your Housing Rights Bulletin, which is packed with great info.
Yeah.
Our mission here is to break down the most essential stuff from these documents and give you a crystal clear picture of where you stand as a renter in California.
Yep, that's what we're doing.
It's your go-to guide for navigating your tenancy in the Golden State.
You got it.
Yes.
Being in the know before things go sideways is the smartest move any renter can make, honestly. It's all about empowerment. When you understand the rules, you can prevent misunderstandings and protect your rights from the very beginning.
Okay, so let's jump right in. What are the things you should be thinking about before you even think about signing a lease?
Before you even sign, the most important thing is good communication. Just talking to your potential landlord up front.
Okay.
About expectations, like who takes care of repairs, what you're allowed to change, any specific rules for the property. That sets the stage for a much smoother rental experience.
Right, laying that groundwork. Now, the guide lays out what legally counts as a rental unit. And it's pretty broad, right? It could be an apartment, a house, a duplex, a condo, even just a room that you're using as your living space.
Yeah, it covers pretty much everything. And during the process, you'll probably be talking to the landlord themselves, or maybe their agent or property manager. The thing is, you basically have the right to deal with these agents as if they were the landlord, at least in most situations.
Makes sense. And knowing who you're actually dealing with is really important.
Oh, absolutely.
Both the guide and the bulletin emphasize that the landlord has to provide their name, address, and phone number, or their agent's contact info, if they have one. This isn't some anonymous landlord situation. It's got to be out in the open, whether it's in your rental agreement or clearly posted on the property itself.
Transparency is key, right, for accountability. Like if you need to give them notice or you have a concern, you need to know who to contact.
Now, there are some kind of unique living situations where the typical tenant rights might apply a little differently.
Right.
This would include people staying in hotels or motels under certain conditions, a single lodger living in an owner-occupied home, or someone in transitional housing. I thought it was interesting. There's a specific rule for residential hotels that prevents them from making guests check out and re-register before 30 days have passed.
Oh, yeah.
It's specifically designed to stop them from dodging the whole tenant rights thing.
It is interesting. The law recognizes that housing comes in all shapes and sizes, and the rules might need to adapt a bit depending on the setup.
Okay, so you found a place you're interested in. Before you even agree to rent, what should you be looking for when you do a walkthrough or an inspection?
Before you rent, look at everything. Don't be shy. Check how sturdy the place is. Are the walls solid? How are the utilities? Test the fire exits, the locks, and please, please, please make sure the smoke detectors are there and that they actually work. Look for any signs of potential problems, like lead-based paint, which is a big issue, especially in buildings built before 1978. Also, any indication of meth contamination. Those are things you want to catch early for your health and safety.
So document, document, document.
Always.
Take photos, videos, anything you can to record the condition of the place before you move in. That documentation can be your lifesaver later on if there's any disagreement about damages or repairs.
100%. And be sure to date and sign those records and make sure photos and videos have timestamps. That's super helpful.
Definitely. And don't forget the practical stuff too, like figuring out who pays for what utilities and how much they typically cost. Take a walk around the neighborhood at different times of day.
Right.
Check out the safety, what amenities are close by, that kind of thing.
It's about more than just finding a place to crash, right? You're becoming part of a neighborhood. Understanding these factors can make a big difference in how much you enjoy living there.
Now let's talk about prepaid rental listing services. These are businesses that sell lists of available rentals.
Right.
If you use one, make sure the contract is clear about what services they're providing, what type of rental you're looking for, and very importantly, your refund rights. You have the right to a refund if they can't provide at least 3 rentals that meet your criteria and are actually available within 5 days, and you have to ask for that refund in writing within 15 days. Even if you end up finding a place somewhere else, they can't keep more than $50 of your money. But here's the catch. You have to ask for the rest back within 10 days after the contract ends.
That's important.
And prove that you didn't actually rent any of the places on their list. So keep track of everything.
Documentation again.
When you're filling out a rental application, there are some things a landlord can ask and some things they absolutely can't ask.
Yep.
They can ask for your previous landlord information, references, maybe your social security number for a credit check, but they're not allowed to ask discriminatory questions. Stuff about your race, religion, gender, family status, disability, or whether you have kids under 18.
Those are hard lines.
Those are off limits.
California law is very strict about that.
Mm-hmm.
However, if you're asking for a reasonable accommodation because of a disability, they can ask for proof of your disability and that the accommodation is necessary.
Right, that makes sense. And if a landlord turns you down based on something in your credit report, get a free copy of that report and make sure everything's accurate. Sometimes it's even worth explaining any negative marks on your application, just to be transparent.
Absolutely. Sometimes a little explanation can go a long way. And speaking of fees, if you get hit with an application screening fee, make sure you know the legal limits. It's not a free-for-all. Back in 2009, the limit was $42.06, and the landlord has to give you a receipt with a breakdown of their costs and refund any part they didn't actually use.
Okay, got it. So they can't just charge some random amount and pocket the difference.
Nope. It has to be tied to their actual expenses.
Got it. And before you sign the lease, you might have to put down a holding deposit to hold the place for you. Just know that you should get that money back if, for whatever reason, the rental agreement falls through. Unless, of course, you're the one backing out.
Exactly. It's like a good faith gesture on your part, and if the deal doesn't work out for reasons outside of your control, you should get that deposit back.
Okay, so let's say you found the place, everything checks out, you've been approved. Now it's time to tackle the rental agreement or lease. What are the key differences between those?
Okay, so the two main types are periodic rental agreements and leases.
Got it.
Periodic agreements, like the month-to-month agreements, renew automatically for the same time period until one of you gives notice.
Mm-hmm.
Week-to-week is an option too. This rental period basically sets how often rent is due, how much notice is needed to end things, and even how much notice they have to give you for rent increases.
Okay, so the rental period drives a lot of the key details. What about oral versus written agreements? Are they both legally binding or does it have to be in writing?
Both are legally binding in California.
Okay.
But here's the thing. Even if you just have a spoken agreement, the landlord has to give you a written statement with their contact info or their agent's contact info, information on who can accept rent payments and how those payments should be made.
Okay.
So even if the whole agreement isn't written out, you've got those essentials in writing.
Got it. Leases, on the other hand, they're for a fixed term, like 6 months or a year. What are the pros and cons there?
Well, the good thing about a lease is rent stability. Your rent is locked in for the entire term of the lease, unless there's a specific clause that allows for increases within certain limits.
Okay.
The downside is that breaking a lease can be a pain. You move out early, the landlord might hold you responsible for the rest of the rent. So it's super important to read every single part of that lease, understand what you're agreeing to, and if anything seems iffy, get some legal advice before you sign.
Yeah, good advice. Now, what about situations with shared utility meters? That seems like it could lead to some headaches.
Oh, it can be. If you're sharing a gas or electric meter with other units, you need a crystal clear written agreement about how those costs are going to be split. Now, California law doesn't have specific rules for water and sewer billing in these shared situations.
Interesting.
So it's really important to have that spelled out in writing too. You don't want any surprises when the bill comes.
No, definitely not.
And another thing, if the negotiations for your rental agreement were primarily in Spanish, Chinese, Tagalog, Vietnamese, or Korean, your landlord is required to provide a written translation in that language before you sign anything.
Wow, that's a huge protection for tenants.
Yeah, it is. There are a few exceptions to this rule, like if you brought your own interpreter, but generally speaking, that translation needs to be provided. And if it isn't, you have the right to cancel the agreement.
That's good to know. So, walking through this, what are the absolute must-haves in any rental agreement or lease? Like, what needs to be there no matter what?
Bare minimum, you've got to have the names of both the landlord and the tenant, the full address of the property, the amount of rent and how it's paid, the length of the agreement, and how many people are allowed to live there. And of course, like we said earlier, the landlord's agent and owner information also needs to be disclosed.
All right, makes sense. Now, even if it's written in your rental agreement, there are certain basic legal rights as a tenant that cannot be waived or limited. Like, those are just off the table. What are some of those untouchable rights?
Some big ones include the limits on how much they can ask for a security deposit. your rights under the implied warranty of habitability, which we'll get into more later, and protection from retaliatory eviction. These are kind of the bedrock safeguards for California renters.
Okay, and then there's this whole concept of a landlord's and tenant's duty of good faith and fair dealing. What does that mean in practice?
It's about being honest and reasonable. Both the landlord and the tenant are expected to deal with each other fairly, and this is kind of an underlying principle woven through every rental agreement, even if it's not spelled out word for word.
Gotcha. All right, last but not least in this section, landlords have some must-do disclosures, things they have to tell you up front.
Yep, and these are important. They're about keeping you safe and informed. For any building built before 1978, there's the lead-based paint disclosure, which should tell you about potential hazards. They also have to give you the federal pamphlet called Protect Your Family from Lead in Your Home.
Good to know.
And if the property was ever used to make meth, that has to be disclosed too. You need to be told about any regular pest control treatments, whether there's a demolition permit in process, if it's near a former military base or explosive site, and the availability of the Megan's Law database.
Wow, that's a lot.
And one more thing, if you're a prospective tenant, they need to disclose the unit's energy efficiency rating. California is all about transparency when it comes to renting.
It sounds like it. That's a lot to keep in mind, even before you move in. Okay, let's move on to security deposits, which I know are a big question mark for a lot of renters. First off, what exactly counts as a security deposit?
Basically, any payment you make to the landlord that's not the application screening fee is considered a security deposit, even if they call it last month's rent, a pet deposit, a cleaning fee. Legally, it's all a security deposit.
Oh, interesting. So it doesn't matter what they call it, it all falls under that umbrella.
Oh. Exactly. And just as important, there are legal limits on how much a landlord can ask for. For an unfurnished unit, the security deposit can't be more than 2 months' rent. If you have a waterbed, it bumps up to 2.5 months' rent. For furnished places, it's capped at 3 months' rent, or 3.5 with a waterbed. And this is on top of your first month's rent. They also can't generally require you to pay this in cash.
Okay, good to know. So, knowing these limits is really important. It's your first defense against being overcharged, your financial safety net.
Right.
What can a landlord legally use that security deposit for after you move out?
They can only use it for a few things. Unpaid rent, cleaning costs, to get the unit back to the same level of cleanliness it was when you moved in, and of course for damages. But that's damages beyond normal wear and tear.
Which brings us to the million-dollar question. What exactly is considered normal wear and tear? Because that's where things can get a little fuzzy.
Right, it can be. Normal wear and tear is basically the natural deterioration that happens over time from using the place like a normal person. So stuff like faded paint, a little wear and tear on the carpet in high traffic areas, loose door hinges, those are generally considered normal and can't be deducted from your deposit.
So it's not just a free pass for the landlord to take your deposit for any little thing.
No, not at all. Your deposit is specifically for damages beyond normal wear and tear and for unpaid rent. Knowing this gives you the power to push back if they try to make deductions that aren't fair.
Exactly. What if a landlord wants to increase your security deposit after you've already moved in? Is that allowed?
They have to provide you with proper written notice before they can increase it. How much notice they have to give would probably depend on what your rental agreement says and any local rules where you live.
Okay. Now, when you move out, the landlord has some responsibilities regarding your security deposit. What are they?
Within 21 days after you move out, they have to send you an itemized statement listing any deductions they're making from your deposit. That has to include copies of receipts for any repairs or cleaning, unless they did the work themselves or have a recurring contract for those services.
What happens if you disagree with some of the deductions?
First thing, try to communicate. Explain in writing why you disagree and ask the portion you think you deserve back. Always keep a copy of this letter for your records. If talking doesn't work, you might think about mediation, or as a last resort, filing a claim in small claims court to get that money back.
Okay. What if the building is sold while you're living there? What happens to your security deposit?
The original landlord has to transfer your security deposit to the new landlord. Then the new owner is responsible for handling the deposit correctly when your lease ends. It just passes on to them.
Got it. You know, one thing the guide suggests that I thought was really useful is requesting an initial inspection a couple of weeks before you move out. Can you explain what that is and why it's a good idea?
Yeah, so basically, about 2 weeks before you move out, you can ask for an inspection. This lets the landlord point out anything they might deduct from your security deposit. And here's the key part. After that inspection, they can generally only deduct for problems they pointed out that you didn't fix, for damage that happens after the inspection, or for things that were hidden behind your stuff during the inspection.
Oh, okay. So it's kind of like a heads up.
Yeah, it gives you a chance to see what they see and maybe avoid losing some of your deposit.
Definitely a good tip. Okay, switching gears a bit, let's talk about a landlord's right to enter your rental unit. I mean, can they just come in whenever they want?
No, definitely not. Legally, they can only enter for certain reasons, like emergencies, repairs that are necessary or that you've agreed to show the unit to potential buyers, tenants, or lenders, if they have a court order, if it looks like the unit's been abandoned, or for that initial inspection we just talked about.
Okay, so there are some specific allowable reasons.
Right. And even then, they generally have to give you 24 hours notice in writing before they come in, unless it's a true emergency or you've agreed to a specific time.
Okay, so it's not a free-for-all for them.
Not at all. Their right to enter is limited, and it can't be used to harass you. Constantly coming in without a good reason or proper notice is definitely a violation of your rights.
Good to know. Okay, what if you need to leave before your lease is up? Or maybe you want to get a roommate. That brings us to subleasing and assignments. What's the difference between those, and what do renters need to know?
Whether or not you can sublease or assign your lease really depends on what your original lease says.
Okay.
A sublease is when you rent the place out to someone else, but you're still responsible to the landlord. You're like their landlord now.
Okay.
It's really important to have a written sublease agreement with your subtenant to make sure everyone's protected.
Right.
An assignment, on the other hand, is when you transfer the entire lease to a new tenant. For you to be completely off the hook in an assignment, you usually need what's called a novation agreement. That's where you, the new tenant, and the landlord all sign a paper basically saying the landlord agrees to let you out of the original lease.
So with a novation agreement, you're basically free and clear.
Yep, it's like a clean break.
All right. So what about dealing with problems that pop up during your tenancy? What's the landlord's responsibility when it comes to keeping the property in good shape?
In California, landlords have what's called a duty to repair.
Okay.
It comes from the implied warranty of habitability, which basically means they're legally required to keep the rental unit in a livable condition. That means making sure it substantially meets building and housing codes that are there to protect your health and safety.
So they can't just let things fall apart and expect you to live in a dump.
Exactly. There's a basic standard they have to meet.
What are some examples of conditions that would make a unit legally uninhabitable? Like, what are we talking about here?
We're talking serious stuff like a roof that leaks because the weatherproofing is bad, no hot water or cold running water, electrical problems that are downright dangerous, no heat in the winter, really unsanitary conditions like a major roach infestation or blocked or unsafe fire exits.
Yeah.
We're not talking about minor inconveniences. These are serious defects that make a place unfit to live in.
Right. Got it. Of course, tenants have responsibilities too.
Oh, yeah, absolutely.
It's not all on the landlord. So what are some of the things tenants are responsible for when it comes to taking care of the property?
You're responsible for keeping the place clean and sanitary, using all the appliances and stuff in a reasonable way, and preventing damage that goes beyond normal wear and tear. But here's the important part. You're not responsible for fixing damage from things like earthquakes or floods, natural disasters. And you're also not responsible for damage caused by some random person who you didn't invite onto the property.
Makes sense. So if something in your rental needs fixing, what's the right way to go about getting it taken care of? What are the steps a tenant should take?
First thing, always notify your landlord about the problem. Do it in writing whenever you can, an email or a letter. That way you've got proof that you told them.
Right.
Be specific about what needs fixing and when you let them know. Then you got to give them a reasonable amount of time to make the repairs.
Okay.
What's considered reasonable depends on the problem. If the heater breaks in the middle of winter, that's a lot more urgent than, say, a wobbly cabinet door.
Yeah. What if they just blow you off or they don't make the repairs after a reasonable time? What are your options then?
You've got a few legal options, but be careful. There are risks with each of them. One option is repair and deduct. That's where you pay to fix it yourself and then deduct that cost from your rent.
Okay.
But you can only deduct up to 1 month's rent, and there are very specific rules about when you can do this, so make sure you know what you're doing.
Got it.
Another option, which can be a little risky, is withholding rent. But this is usually only a good idea if the landlord is seriously failing to meet their obligations and the place is becoming unlivable. And even then, if it's not done correctly, it could lead to eviction. In extreme situations where the unit's genuinely uninhabitable, you might be able to just leave and stop paying rent. But even then, usually you still have to give proper notice.
So this is where it's important to know the specifics, right?
Absolutely. And the final option is taking legal action. You can try to force the landlord to fix a problem or sue for damages because of the condition of the place. But if you're in a situation where your landlord's ignoring their duty to repair, it's usually a good idea to talk to a lawyer and figure out the best way to handle it.
Right. That makes a lot of sense. And for renters in Orange County, Riverside, San Diego, and Los Angeles, there are resources like MartinezLawCenter.com that specialize in these types of situations, right?
Yeah, they can be really helpful.
Okay, so let's touch on some specific situations that can come up for renters, like what happens if the owner decides to convert the building to condos?
Well, if your landlord decides to convert the property to condos, they have to follow some specific procedures, including getting the right approvals and giving tenants proper notice. They usually have to give you 90 days notice before they can even try to sell you your unit.
Okay.
And a lot of times, tenants get the first chance to buy their unit before it's offered to anyone else.
What about foreclosures? That can be a pretty scary situation for renters. What happens then?
Yeah, if the property gets foreclosed on while you're renting it, in most cases, you're entitled to at least 60 days notice to move out. That protection comes from federal law.
Okay. One last thing on this. What if the landlord wants to demolish the building? Do they have to tell you about that?
Yeah, they can't just spring that on you. They're legally required to give written notice to all tenants before they even apply for a demolition permit. That just makes sure you have time to find somewhere else to live.
That's good. It seems like there are a lot of protections in place for tenants. All right, let's move on to ending a tenancy, whether it's the tenant deciding to move out or the landlord ending the agreement.
Okay. What are the notice requirements? If you want to end a month-to-month tenancy, what do you have to do?
You need to give your landlord written notice at least 30 days before you plan to move out.
Okay.
Unless your agreement says you need to give more notice.
And for week to week?
For week to week, it's usually 7 days written notice. And it's always better to give more notice if you can.
Right.
And always do it in writing so you have proof.
Good advice. What about when the landlord wants to end the tenancy? How much notice do they have to give?
It depends on how long you've been living there. If it's been less than a year, they generally need to give at least 30 days written notice. If it's been a year or more, they have to give you 60 days notice.
Okay.
But be aware, local ordinances can sometimes change these rules, so it's always a good idea to double check what the rules are in your area.
Can they just email you these notices, or is there a more formal process?
There are specific ways these notices have to be served to be legally valid.
They can deliver it to you directly, leave it with someone responsible at your place, and then mail a copy, post it on your door, and then mail a copy, or send it by certified mail.
Okay.
Certified mail is good because it proves they sent it and you got it.
Gotcha. Now, if a tenant doesn't pay rent or violates the lease agreement, the landlord might give them what's called a 3-day notice, right?
Right.
What does it mean if you get one of those?
A 3-day notice is serious business. It's an eviction notice. If it's because you haven't paid rent, you've got exactly 3 days to either pay up or move out. And weekends and holidays don't count towards those 3 days. If the notice is for some other kind of lease violation, it has to say exactly what you did wrong, whether you can fix it, like maybe getting rid of an unauthorized pet, and how long you have to fix it. Basically, take a 3-day notice very seriously, and if you get one, talk to a lawyer right away, especially if you think it's a mistake or you're not sure what to do.
And for tenants in Orange County, Riverside, San Diego, and Los Angeles who are facing eviction, organizations like MartinezLawCenter.com focus exclusively on representing tenants, so they can be a great resource.
Right, they can.
What happens if a tenant doesn't move out after getting proper notice and the notice period ends?
If that happens, the landlord might start the official eviction process through the courts. That's called an unlawful detainer lawsuit, and it's filed in Superior Court.
Okay.
This type of lawsuit is what's called summary, which means it moves through the court system really fast. Once you get officially served with the lawsuit, meaning you get a copy of the papers, you usually have only 5 calendar days to file a written response with the court.
5 days? That's a really short time.
It's a super short time frame, and that's why it's so important to act fast if you get those eviction papers. As a tenant, you have options. You can file an answer with the court, which basically says you disagree with what the landlord is claiming, or in some cases you can file what's called a demurrer. That challenges whether their complaint is even legally valid. But here's the thing. Ignoring the lawsuit is a huge risk.
Right?
Because if you don't respond, the court can issue a default judgment against you. You automatically lose without even getting to tell your side of the story.
So not responding is definitely not the way to go.
Definitely not.
Yeah.
Usually there are filing fees when you submit a response, but you can usually get those fees waived if you can't afford them. This whole process can be really complicated. You need to understand your options.
So if you're in that situation, it's probably smart to get some legal help.
Right. For tenants in Orange County, Riverside, San Diego, or Los Angeles who are facing an unlawful detainer lawsuit, reaching out to legal professionals who specialize in tenant rights, like the folks at MartinezLawCenter.com, can really help. They can walk you through the process and even represent you in court.
So if you're in this situation, definitely don't try to go it alone. What happens if the tenant wins the lawsuit?
If the court sides with you, the tenant, you won't be evicted. And the court might even make the landlord pay your court costs. They might even have to pay your attorney's fees, but that depends on whether your rental agreement includes what's called an attorney's fee clause.
Okay. What happens if the landlord wins the lawsuit?
If the landlord wins, the court issues what's called a writ of possession.
Okay.
This basically tells the sheriff to remove you from the property.
Yeah.
Once the landlord gets this writ, the sheriff will give you a notice to vacate the premises, usually within about 5 days. And if you don't move out by then, the sheriff can physically remove you from the property and change the locks to keep you out. That's the final step in the eviction.
Are there any options for tenants to appeal an eviction order or to try to stop it from happening?
Yeah, you can appeal the court's decision if you think the judge made a mistake. But even if you appeal, you'll probably still have to move out while the appeal is going on, unless you can get the court to issue what's called a stay of enforcement. A stay is a temporary order that stops the eviction from going through. In some cases, you might be able to ask the court for relief from forfeiture.
Okay.
That's where you ask the court to let you stay, even though the landlord won, if you can fix the problem that caused the eviction, like paying any back rent and costs. And if you miss the deadline to respond to the lawsuit, you might be able to get the court to set aside the default judgment, but you have to have a valid reason why you didn't respond on time, and you have to act fast.
Right.
Filing for bankruptcy usually puts an automatic stop to evictions. But there are exceptions, and it's not always permanent, so it's really important to talk to a lawyer about what bankruptcy means in your specific situation.
Definitely sounds like it.
All of this stuff can be really complicated, so getting legal advice right away is key. Again, if you're in Orange County, Riverside, San Diego, or Los Angeles and you're in this situation, experts like the ones at MartinezLawCenter.com can really help you understand your options and navigate the legal system.
Okay, let's move on to a really important topic, landlord retaliation and unlawful discrimination.
Right.
These are some of the strongest protections tenants have. So first off, what is landlord retaliation and how does California law protect tenants from that?
Landlord retaliation is a big no-no in California. They can't punish you for standing up for your rights.
Okay.
So for 6 months, after you do things like report unsafe conditions to the authorities, ask for repairs, or get involved with a tenant organization, your landlord can't retaliate by trying to evict you, raising your rent, or cutting off services.
Okay.
If you think your landlord is retaliating and you're current on your rent, this can be a solid legal defense against an eviction. The landlord would then have to convince the court that their actions were for a legit reason and not just revenge. It's important for tenants to know about this protection so they can stand up for their rights without being afraid of what the landlord might do.
And discrimination, that's a huge one. We know it's illegal, but what are the specific things California law protects tenants from when it comes to discrimination?
California is really serious.
Call now 714-442-9741. Thank you.